Hello and welcome to Assemblies of the World with me, Anna Isabel. And today, once again, I have Marc Horn with me. Hello, Marc.
Hi, Anna, and hi, everyone. How are you? Nice to be here again.
It's lovely to have you back because it's good for us to have a, a deeper understanding of the framework on which our law is built.
Hmm.
And watching the Peacekeepers videos on YouTube and talking about the means by which you started to head towards triggering a judicial review over
Hmm.
various issues around council tax, it seems that the concept of open justice
Yeah.
came up a few times. So I thought it would be really good for us to expand on that today, so that we have a proper understanding of what this principle, which
Hmm.
seems like a big cornerstone of the foundation of our law system, actually is. So, Marc, tell us, what is open justice?
I mean, basically, it's absolutely fundamental because a judicial system, the public must have confidence that it's a fair and just system. So, what you've got is a judiciary who are actually uh, implementing justice on your behalf. So, open justice fundamentally is about transparency and accountability so that everybody is aware of the due process of law and at any point can watch the due process of law and because they are carrying out justice in your name. So, really, it's a very, very broad concept, but absolutely fundamental to the rule of law because it all is based on confidence. People having confidence that the judiciary is doing its job according to law. So that is the very broad aspect of it, and it's absolutely foundational. So it's really about uh, openness, i.e., access to the courts, access to all the ongoings, i.e., the submissions, the paperwork, watching the process of how the courts are operating. And at the end, the judgment comes to understand the application of the mind, the logic and reason to the evidence, which results in the decision. So it covers everything from the start to the end, as without public confidence, a justice system is worthless. So it's absolutely foundational.
So, are there any circumstances in which this does not work? As in, are there any exceptions to the rule?
Yeah. Now, basically, it's about making sure that justice is not only seen to be done, but is done. However, there are basically certain circumstances where it may result in an injustice. So, largely, you'll find that there are restrictions on the open justice principle when there's children involved in a case. So you'll find with a lot of family matters, the names of the children won't be exposed. It'll be child A and child B or so forth. And that there's for good reason, so that the children don't get picked out at school or get bullied on or your parents are fighting or whatever. So that there would be one good reason. Uh, and there's no need for the children's names to be made public. Uh, so, uh, other circumstances, um, again, what they actually do is, for instance, police informers, they'll withhold the names. However, that there is questionable because you have the right to face your accuser. And that there's a fundamental right. So And so it's a balance really of proportionality. Is there the risk of the due process of law being perverted if the principle of open justice is not applied? Other examples of it would be what they do is you can make emergency applications in private. So, for instance, if somebody uh, say you owe me some money and we've got a contract and I've got a court order and you've breached the court order and not paid me, I could apply to the court for a attachment to your property, i.e., get the court to give an order to attach your debt to your assets. So, for an example of this is a charging order. So, with the charging order, if the due process of law say to list a case to make a charging order is, say, for argument's sake, 3 months, you could actually sell your assets to avoid having the assets attached to the debt. And so they put in an interim order based on one party providing the evidence. And if that evidence suffices, then they'll make an interim order pending the outcome of the case. And so you'll not be notified of it. And as such, it's done in private, not in the open. And again, for good sense, in the name of justice, if you don't pay your obligations or you don't fulfill your obligations, if there's a mechanism for you to fulfill them, in order to avoid you getting rid of those and thereby denying me the right to what I'm entitled to, it makes rational sense in something like that. Another example would be, say, for instance, a warrant to search a house. If there's good reason for the police to suspect that, for instance, you got stolen goods in there, if they said, okay, there's going to be a court hearing in 3 days' time to see if we can come and inspect, search the house, they could remove all those items. And that would thereby nullify the whole purpose of the application for a warrant. However, the problem with this is because it's not done in open, is that how do you control abuses of it? So, for instance, with the warrants, in the olden days, if I came to the police and I reported and said, right, Anna's got illegal goods A, B, C, D, which she stole from blah, 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 in her house, the person that gave that information actually, if the information was wrong, used to be locked up because they were trespassers. They were lying. So what this meant was that your informants were at risk of having a case brought against them if they can't provide good evidence as to their belief. And if their belief is wrong, they carry the risk. That no longer happens. And so at least then you had a check and balance, really. Because just because somebody says so and it's convenient and stuff like that, anybody could go to the police and say A, B, C, D. If they believe you, they'll just make a warrant and come and raid your house without good reason to breach your peace. Because to breach somebody's peace, you must have the evidence in advance. So definitely there are circumstances where it does make sense, but it's a very risky thing because it's not being done in the public and there's not accountability for the potential wrongdoings. It's about checks and balances.
And that's brilliant because in giving us those exceptions to the rule,
Mm.
you are also demonstrating why the rule is so important.
Oh,
Because
yeah.
the minute we step away from that visibility,
Mm.
we lose accountability.
Yeah. Basically, when people are observed, their behavior is very different to if they're not observed.
And this is so important because when you are acting to mediate in
Mm.
disputes,
Yeah.
whether it's disputes between individuals,
Hmm.
where one individual is particularly in situations where one individual is more powerful, as in
Yeah.
higher status or more money, it's
Yeah.
really important that we see that they are not being favored. So
Correct.
it's that's also that's very clear. But also when it's between an individual and the state, it's actually arguably even more important
Yeah.
because when a person is in court, really what we are asking for is that there be a fairness and that nobody is allowed to bully somebody else
Hmm.
and that power and money become irrelevant
Absolutely. Yeah.
in the case.
Mm.
But that's much, much harder to ensure that that's the case if
Yeah.
there is a lack of transparency. And so this is the principle then of open justice.
Yeah. Basically, what you've just described, really, when it's the state against a member of the public, the state has got limitless resources in essence, as opposed to an individual member of the public. And that there's basically called an inequality of arms. And so through the open justice, because if all are equal under the law and nobody's above the law, there should never be an advantage to either party. And the due process of law, what we were saying last time is when disputes can't be resolved in the private, then they must go to public dispute resolution to stop the private people bashing one another over the heads and resolving things with violence. So the first duty is for public dispute resolution, it must be a neutral venue, i.e. an independent venue where public have access to resolve their disputes. The first job then of the judicial officers, so that's the magistrates, justices, judges, whatever different levels they are, but the decision makers of the to resolve the dispute is to find out what is the relationship between the two parties. Then they need to determine uh, is there a lawful cause of action? Has somebody breached their promise to the other person? Because ultimately it's about promises. Promises create a binding agreement. And that can only be done based upon the evidence. So once they've got the lawful cause of action, but that there must come from the evidence, and the whole process then of determining guilt or not guilt then as to whether a breach did indeed occur uh, can only be contained within the evidence before the court. And anything which biases either party is a contempt of court. So if there's any undue influence in any manner, if somebody's manipulating evidence or denying the right of evidence being put forward, or not allowing one person to cross-examine, or one person can't fully speak, or telling you what you can or can't use as your defense. Because ultimately, so long as you can evidence harm, all the rest is, definitions. If you're harmed, you have the right to remedy in a neutral venue. So it's all about basically anything which impedes or biases one party, an inequality of arms, basically. And it could be money, could be the state against you. And this is very much a real problem, because if you bring a case as a litigant in person, basically they've got deeper pockets. And so even without good reason, they will just slap. And generally with litigants in person, the very first thing they do, doesn't matter what the merits of the case or that, doesn't matter. They will put in a strikeout application and threaten you with costs. That there's an undue influence on the due process of law, and that creates fear, and that basically is a bias.
It's so many thoughts, cross my mind as I'm listening to you. And I guess one of the first is that it's the beauty of our legal system.
Mm.
We have got so used to it being corrupted, manipulated, and generally abused, that we have forgotten how it should be and the principles on which it stands. And the principles on which it stands are so visionary in a sense, and so right, that it makes it all the more criminal to be witnessing the extent to which manipulation is corrupting it. And one of the great things that has really, great as in huge things, that has been bothering me for absolutely years now, is the fact that the average person cannot seek remedy in the courts, from corporations, from government, because they cannot afford to go to court. And how can we possibly have a society in which we say that there is a judiciary that's functioning when the majority of the population are locked out of it by virtue of not having means? And legal aid, imperfect though it is, at least was a principle that was there once upon a time, that was to act as a remedy. And so this is, we talk about the importance of the NHS and the health service, but I've always felt that if we neglected the judiciary side of things, that we don't have a society. And here we are, in our time, in which everything is broken, including our judiciary. And what you're doing is you're saying, okay, let's see how it should work. Let's understand how it should be working. Because unless we understand how it should be working, we have no idea of how to get back to that.
Yes. Yeah.
So listening to you, that is so clear to me, that this is a beautiful system that evolved over time, and which has been very badly, I think, manipulated and hijacked. It would appear.
Okay.
So you're not so sure that it's been hijacked.
You've expressed a lot of terminology that is out there. Okay. Manipulated, hijacked, things like that. I look at it very differently. Okay. And essentially, those who govern, and so that there's Parliament, the executive, the government, and the judiciary, okay, they are in a position of trust. And the question really is, as opposed to are they corrupt? Are they manipulated? Firstly, for corruption, you need to prove it. Okay, you need evidence for that. Um, and so, uh, so then the question really is, how have we got here? Because basically, what I've described, the judicial system as being an impartial arbitrator of dispute, it does not matter whether it's the lowest guy on the planet whose language is incredibly bad versus the highest and richest in the country. The whole idea of the judicial system is to balance and allow each of them to present their best evidence and their best case. So that may mean that you do provide assistance and basically, in effect, if you don't speak the language, you're provided with an interpreter. But it's the whole process that you need to be made aware of. But we have entrusted governance to people. So I then look at it, how do people, what's human nature? And human nature is, bluntly, we do as little as possible for as much as possible. Okay? So that means we shortcut. And it's about, literally, it's a bully. Once they start to learn to live off other people's money, it becomes the normal behavior. Whose fault is it? Is it our fault for allowing that? Because if we were in the same position, more than likely we would behave in the same manner. Unless we are not morally corrupt. So the corruption, I agree, is an issue of morality.
Oh,
Am,
yeah.
I'm in a position of trust. If I abuse that position of trust, then it's moral corruption.
It is. And yes, absolutely. It is moral corruption. And there is plenty of evidence all around us for that. Um, and yes, I think there's a lot that goes on behind the scenes that would make us all, very cross as well. Uh,
Yeah,
so the corruption is there. And I guess what I'm expressing is the feeling that the general
yeah.
public have with the fact that here we have this judicial system that
Mm-hmm.
is meant to be fair and just and equal for all,
Mm-hmm.
and it is not working in that way. And
Correct.
what we're saying is, okay, you need to know how it's meant to be working,
Yeah.
so that in the event that you find yourself in need to be there, you
Mm-hmm.
are able to stand your ground and say, excuse me,
Correct.
do you remember fairness? And
Yeah.
do you remember the principles on which this court is built? So I
Mm-hmm.
think that this is the reason why we're having this conversation, because for many of us, we never got that education. So when we say, how did we get here? We got here because we have not been taught about the beauty and the value of the judicial system that is our birthright in a sense, because our ancestors evolved it. And
Yeah.
for our part, we need to look after it, maintain it, and evolve it further, because
Yeah.
our ancestors could only work with the information they had at the time in this.
Mm-hmm.
And our society has grown and evolved over time also, and so we need to ensure that the new challenges
Mm-hmm.
are in some way dealt with
Mm-hmm.
in the fairest way possible. So this is about us also having to, at this moment in time, learn. And
It's interesting that point that you just brought up there, because not many people are probably aware, but they've just gone through a public information gathering thing, whatever they call it, a public questioning survey, whatever, from the Ministry of Justice on the open justice principle. And really, it's about looking more or less what we're talking about. You're looking at the issues. And one of the issues really is in regards to application of knowledge. So if you look at, in the olden days, you used to have stenographers just typing up word for word what is said. That there was replaced then with recording machines, so that you could get a word for word record off the recording machine from, more typists, because stenographers are were very, very specialized. Today, everybody's got a mobile phone. So we actually all could make our own record. However, to pay for those services in the past, or to have those services, monopolies were granted where you had specialists who could take transcripts off recordings, and we've still got them today. So at the time, when they moved stenographers out of the courts for economy, there's no reason we shouldn't take advantage of, doing things efficiently. And now we're at a point where, because you and I can record everything in the court, is there really still a need for having to pay for a transcript from the official court record? Now, there could be a good reason for this from the viewpoint to stop the parties arguing. If I've got a recording and you haven't, okay, I can play the recording, and in all probability, you would agree then whether that there was a true recording of the court or not. And then we can just put it on the internet and we can get a transcript. And all of that costs us next to nothing. So we're moving forward now from into the tech age, i.e. we've got new technology available, which creates new possibilities. And therefore, should we not just simply, we've got a webcam, you, wherever you are, I'm wherever I am, and here we can both record it. What's the problem? Should courts not be live transmitted? And anybody can record it. Because
I think that's a very good question, because if we fail to sort this out and allow for live transmission, now I am an editor, I can edit.
Yeah.
And so anytime I see something, my question is, has this been edited?
Yeah.
And I think the abilities, particularly with AI, etc., to create things that are not real,
absolutely,
it makes it extremely important that we're looking at something that is a live transmission and that is recorded by more than one party, so that we can all agree on what happened and that the evidence has not been tampered with.
Correct.
So I think that's a huge issue. But again, so each time that we're picking out a different element of this, we're seeing so important why this is such an important issue. And that's why I felt that we needed to discuss it. Now, so
can I just quickly share a screen for a second here?
Of course, yes.
Okay, because we've mentioned, or there was mention of corruption. Okay, and with that, okay, this here is basically the summary of this initiative to gather and seek information. So this is from the courts and tribunals, judiciary, and it's all about transparency and open justice. Okay, this here's the conclusion of the research. Now, if you look at the key objectives, okay, they're trying to concentrate. What do they feel is important to change? Open courts, that the public, including representatives of the media, can access court and tribunal hearings, includes physical access to the court and tribunal administered by HMCTS and remote access to hearings. That's exactly what we're talking about. Technology has moved on, so we can move it. They are trying to adapt and move with it. Open reporting. Now, what's interesting here is open reporting really previously has only been an issue about media. And what they're talking about now is because of public citizen journalism, public and media can freely report. Open decisions, what we were saying about the transcripts and having access to the judgments, they should be publicly available. And open documents, and this is one that many people aren't familiar with, open documents for people to understand better the due process of law and making submissions and the information, the due process, they're actually talking about of increasing the availability of skeleton arguments, the submissions. That way people can learn how to make submissions themselves and rely less on the courts. Okay, so this here has just come out in the last few days. And when people are saying that the judiciary is corrupt and manipulative and they are trying to take it down a secretive road and look to get their way, this here shows you exactly the opposite. So it really is this, so it's not all bad. There are a lot of good people who are pushing for this.
And that's the reassuring part is
Yeah.
understanding that there are people there who are still very committed.
And the old value, the importance of, because history shows us. And the interesting thing about justice and the rule of law, without a fair and just society upholding the rule of law, you're living as outlaws. There is no social coherence and no possibility of social coherence without the rule of law. And hence, the rule of law is foundational to a society. And therefore, really, the rule of law should always be free to anybody.
I will.
With the proviso, if you abuse it, you will be punished.
I will speak on behalf of animals because I feel that you have done them a great injustice. Most animals manage to live peaceably with each other, at least within their own
community. No, I absolutely agree. If you look basically at wolves, if you want to make an analogy with wolves, okay, the stronger lead the pack and are behind the pack.
That's right, they are.
Okay, and they look after the ones in the middle and
they
protect
do.
the ones
exactly.
in the middle.
I think
and that's what the rule of law does for us as human beings.
Animals manage themselves very well.
Absolutely. Totally.
What we're talking about is regressing to dark
and no animals behave like humans, I'm afraid.
Yeah.
You'll find this nonsense with animals.
I think that darkness, what we're talking about is regressing to dark periods in our history where might is right, and we want to avoid getting into that. So it's reassuring that we're looking at this. So maybe I guess what would be good, Marc, is to very clearly say or explain when we are going into a courtroom, what might we expect as elements of open justice?
Right.
So are we, can we bring in, friends as witnesses, or, what might we expect?
Right. If you go to the Supreme Court, you will see how every court should operate. You walk in and they welcome you and they say, please feel free to walk around, take photographs. Do not uh, interfere with the proceedings. So if you want to watch what's going on, do so very quietly. Don't shout out. Just sit there and you're very welcome to watch. But you can't film inside whilst proceedings are ongoing. Uh, and feel free to ask any questions of members of staff, uh, but do not interfere with the proceedings and have a lovely day. That's open justice. You can go in, you can ask, you can find out, you can watch, you can observe, you're not restricted. Other than the issue of filming proceedings. And they tell you exactly all of this. But if you go into magistrates' courts, they make it as difficult as possible for you to get into the public gallery. They, it's all bullying and threatening and intimidation, exactly the opposite of what the Supreme Court is. So, as an example, really, the Supreme Court shows you what every court should be like, and that they will filter down over time. So the Supreme Court, you can actually they broadcast the cases. But what you've got to bear in mind is the Supreme Court deals with a very small number of cases. So it's relatively not a massive problem. The Magistrates Court deal with almost half the cases in the country. And so broadcasting started in the Supreme Court. Already a lot of the appeal court stuff is broadcast. Some experimental and parts of Crown Court things are broadcast. So you can see as technology is coming in, it's bringing that down to the magistrates' courts. And what I showed you basically is this is what they're talking about. Literally bringing open justice into the magistrates' courts. And that there will allow observation of the magistrates. And it's in the magistrates' courts where most of the injustices that people feel are being affected by what they perceive as injustices. However, if everybody better understands the due process of law by watching, we encourage people to try and go into the courts so that they can observe the due process of law. By learning what the due process of law is, they have an idea of what it should be. And when they witness something that isn't the way it should be, those people should be held to account who are not doing their job. But if you don't know what it should be, how can you judge whether they are doing their jobs properly and hold them to account from that? So it's all moving in the right direction, but it's the lag, really. So many of these things, it'll become inevitable. It will become the normal that anybody can record in the court. That's where it's going. It's only technology that's allowed that to start. But because humans do not like change, we've always done it like this. Therefore, it's okay. We've got no reason to change. This is how my daddy did it. And, daddy didn't have a mobile, so he used to have a landline. Therefore, you must have a landline. So all of this it will move to, within less than 10 years, it's not going to be an issue about watching the magistrates' court on TV or making your own recording. It's about creating that change. And like I've shown there, the judiciary is looking at the open justice because it's so important that people understand how they will be judged in order to make to satisfy themselves, to have confidence in society at large being a lawful society and getting justice. So I mean, it's come a long way over the thousands of years, and technology is allowing it so that literally everybody, instead of watching the news, can just sit at home in the evening, watch the highlights of a court case.
Well,
That gives them a good understanding of what's going on here. And that, in essence, means that really, once people understand this, 90% of the legal profession will not have a job. Because to keep their jobs, they actually have to keep their knowledge secret. Once the knowledge becomes open, that they all of a sudden removes the competitive advantage through the openness of transparency, open justice principle that makes it available to far more people.
and that then removes the great barrier that most people have to justice because they are more likely to be able to represent themselves adequately and not have to deal with the huge fees that are make actual seeking justice prohibitive.
Absolutely, and that's the fear, the mechanism they use now. You might be right, Anna, but do you want to risk £10,000?
Yeah, yeah, and that's the bottom line there. Well, Mark, thank you very much for helping us look deeper and understanding our judicial system and reminding us of the reason why it is indeed so important that we educate ourselves as to how this legal system works. And so I will be putting a link to the peacekeepers yet again in the description box to give everyone the opportunity to learn more. And I imagine that through the website they can also find you.
Yeah. There's comments boxes. Basically, the whole website. You put your comments in there. The only thing we'll do is if sometimes people have a problem with putting in a comment, and so they'll put it 2 or 3 or 4 times, sort of, or repeat the comments and things. But we don't go through and delete stuff. And if you go through the contact us, that'll put you in email contact.
Good. Okay. Well, remind us again of the website, please.
Right. It's Peacekeepers, peacekeepers.org.uk.
Brilliant. The link will be there, as will the link to the Community Assembly of the British Isles. If you have not yet joined, now is the time to do so. And if you have, fantastic. Make sure that you are part of an assembly or starting one or doing something to help build this new and happier world that we are all seeking. Until next time, goodbye.
Thanks, Anna. Bye.